Good evening. I would like to open the meeting of the Walker Planning Commission for Wednesday, December 3. First action item on the agenda is review the meeting minutes. We've got minutes from November 19 as well as November 5. November 5 was a work session talking about housing strategy and the initial discussions concerning that. And the meeting on November 19 was a regular Planning Commission meeting. Commissioners, if you've had a chance to take a look at those, is there anyone offering a motion?
I would move, Mr. Chair, to adopt both sets of minutes.
I'll support.
Okay, motion by Rob, supported by Jacob to approve the minutes for both meetings as submitted. All those in favor indicate by saying aye.
Aye.
Those opposed, same sign. Motion carried. Next item is general public comment. I'd like to bring to your attention, I'd imagine there's a number of you out there that are here for the first action agenda item with respect to Windemere condominiums. Just wanted to let you know ahead of time that this is not a public hearing. It's a matter of the last meeting that was took place. There were the project was tabled to allow for the applicant to address two different items, and so what we're going to be discussing tonight are those items, and then our intent is to deliberate on taking action on the request at hand. So there won't be any time set up during that discussion to invite public comment. However, at this point in our meeting, we always have something for general public comment. So if someone wanted to provide comment about the project, this is their time to do so. We'd limit it to no more than a 2-minute commentary, and then that way we can address those comments. We'll have them fresh in our mind as we go through our deliberations, and then we'll go forward into the meeting. So if there's anyone that wants to come forward. And please give us your name and address, please.
My name is Mary Kay Greening. I live at 3436 English Hills Drive in Walker. And this is actually my final statement too. I have had a lot of correspondence with Paula and the commissioners. The past several months have been extremely stressful for all of our residents. I have corresponded with several letters and emails addressed to Paula Preby and members of the Planning Commission. I hope that they were read by all of you. You know that now our biggest concern is for the safety of all of our residents and the impact that opening English Hills Drive would have on us and the character of our neighborhood. My last letter I sent did address a fair amount of information that I read in the master plan with the city of Walker. I know that according to the zoning ordinance that the Planning Commission makes and adopts the master plan, it states, the Planning Commission shall make careful and comprehensive studies of present conditions and have due regard to the neighbors and neighboring territory.
You have 1 minute.
My letter did mention many items that pertained to the existing neighborhoods, an important one being preservation and protection of existing neighborhoods. This designation is characterized by existing residential areas that are fully or nearly built out and have existing character that is highly valued by the residents. I'm asking the Planning Commission to stay focused on the master plan and protect and preserve the English Hills and English Ridge communities and deny this development so we can continue to enjoy the character of our neighborhood that is so highly valued by all of us. Thank you.
Thank you. Anyone else? Okay.
I'm Renee Curtis, 3313 Ipswich Drive Northwest. 29 years there now. Coventry leads from a hectic alpine to an oasis that is scenic, peaceful, and a low-traffic zone. We were informed at our last meeting that the possibility existed the Ipswich dead end would be extended to accommodate the housing project. This would allow a vehicle overflow to surge into our neighborhood from both Alpine and the housing project. Instead of subjecting already existing residents to this increased traffic setting, remove this burden by extending a road from their development to Bristol where they can easily gain access to an outlet without overtaxing already existing residents' walker. Additionally, the residents of English Hills will maintain their peaceful residence and keep traffic low. Another concern regarding traffic is that both Alpine and 4 Mile will suffer. As stated in the City of Walker's 2003 Master Plan, Sub-Area Section, page A32, of note is the intersection of 4 Mile and Alpine, which currently operates over its designated or design capacity. It also states on the same page, traffic congestion in the area has led to significant increases in traffic accidents. This housing project will overtax an already burdened traffic situation.
1 minute.
Presently, a sign on Coventry's turnoff from Alpine states there is no outlet, thus keeping the traffic down. Traffic from Alpine would increase if drivers now felt they could turn onto Coventry for a shortcut. The Walker 2020 Master Plan on page 18 states as follows. Local residential streets are those that are lightly traveled and meant to provide access to residential areas. Movement of through traffic is generally discouraged on local streets. Examples of local residential streets in the Alpine Bristol neighborhood are Coventry Drive and Greenwich Drive. The Walker 2020 Master Plan of page 34 states, residents in the English Hills condos and the Ipswich neighborhood have become accustomed to a wooden backyard in the former golf course. When the golf course is developed, a buffer of trees and natural space should be maintained in order to preserve this value aspect of life in the neighborhood. Also adopted on August 12, 2024, rezone residential growth 2 to 4 units per acre can be changed to neighborhood preservation.
It's time. Thank you.
Thank you.
Patricia Foss, 901 Coventry Drive. We have all heard the news that Raising Cane will be coming next year in the former Fridays location. More traffic on Alpine. Our service road will be used even more by people that don't already know about it. They will find that road. They did the last time when the service road was built. It took about 2 weeks for people to use that as a cutoff to go into the mall. If a road is to be built on Ipswich, there will be so much more traffic and people will use this road as a cutoff to avoid Alpine to get to this new restaurant and to also get to other stores. The developer stated that Coventry would be used for construction vehicles, which would last for 2 years. On the corner of Ipswich and Coventry is a Kennewy Hills bus stop for elementary, middle school, and high school students. How safe are they going to be?
1 minute.
How about all the little children that live on Coventry and Ipswich? Would you like your child or grandchild to live on these roads? Before you vote, think about the traffic, the little children, the school-aged children trying to get their bus stops each day in the morning. This is a nightmare about to happen if you vote in the favor of the developer. Thank you.
Thank you.
Carl Greening, 3436 English Hills Drive. I'm the one that sent in the letter that said, if you build it, they will come. So it's an old saying from a movie, if you build it, they will come. In the memorandum of the Planning Commission, November 25th, 25, is noted that page 14 of section 277, 11.02.c.7 zoning ordinance, that items 5 and 7 are not satisfactorily met. Both items refer to how the development would easily adversely affect the surrounding area and neighborhood. One other thing, if the master plan is not followed, then fact one, item one regarding designated residential density will be disregarded. Cut it short. The big concern, of course, is the cut-through traffic from Ipswich area, which includes several streets in Coventry, to the development of 4 Mile Road, and the future golf course development, which would definitely burden English Hills roads because of the road is narrow with no sidewalks. Safety becomes a huge issue to our senior residents who have to walk on that private road.
1
And I'm
minute.
just hoping that this commission has our six when it comes to this, the safety of our citizens. I appreciate it. Thank you.
Thank you.
Hello, my name is Rachel Powers. I'm a resident of 3375 English Hills Drive. I want to say thank you for allowing us some time to speak here. I'm a rehab nurse going on my 12th year of practice and a resident of English Hills. I have a handicapped mother and a handicapped brother. I have a question for you. Respectfully, I just want to know what we're still doing here with this whole plan. Have we learned nothing about the importance of supporting the quality of life of the elderly and handicapped people over the last 50 years of our greater community? What is the city of Walker actually about? What's actually important to you guys? You know, at this point, I'm feeling personally harassed by a company that just won't let this go. They happen to have a tough parcel of land. They want to make money off of it. I can't blame them for that. But you've already heard the outcry of all of us during the summer, bringing forth all of these safety concerns, you know, just like what Carl just said. Like I said, so I can't blame them for trying, but I'm really sick of this, like, ooh, what about this angle? Or how about this study? Or, well, you know, maybe this, like, background threat of, well, we could always litigate if possible. And it's just not nice. And I'm really, really tired of it, and I'm not going to stand for it. And I really hope that you guys understand, you know, this is a nice little community. It's wonderful little people. Let's keep it
1
that
minute.
way. It helps our community. It helps the whole city to have these little pockets of just protected good people, good community, good things, especially for the people who are aging, okay? I would be ashamed to keep pushing this, to be honest. I would really feel ashamed to be those people just keep coming after us. So I ask, what is really important to the city of Walker? And I hope you agree, and thank you for your time.
Thank you. Please, if you could hold on clapping and the like. Thank you.
Hi, my name is Jerhan Hawkins. I live at 3377 English Hills Drive. I have spoken before, and I know that people who are still looking at 1989, I believe, when all of the legal paperwork was written up, times have changed dramatically, and we're not living in that same time. And so I was thinking today, golly, when I was 4 years old, I fell out of the car. My mom didn't notice I was missing. I don't know why. But anyway, they got home. My brother said, "Mom, where's Geraldine?" And I was gone. So she backtracked and found me, and luckily a crossing guard had picked me up out of the highway. And so it was a very traumatic experience. I still get teary about it because it was horrific. Laws and rules and caring communities have looked at issues like that and said, well, maybe seatbelts might be a good thing. Change is inevitable.
1 minute.
And change is good. And so I remember when the seatbelt law started, people in the old school, we don't need seatbelts, we've always driven without these things, I'm not wearing them. There was a huge upraising about it. And so I guess my point is we can't live back in 1989. We have to look at the environment, the safety for the community, the value of the property, everything that has been of value here to our board, to our community, I would support. And backing up and just saying because there's some legal documents floating out there that are a little, not real clear, that doesn't mean we jump to those. We move forward and have a community that we can all be proud of and feel safe in and look at each other and say, we are a community. And I hope you will be part of our community and love it as we do. Thank you.
Thank you. If I may, if a lot of things have been said on those prior meetings as far as viewpoints that you have, and we're at this point, we want to focus in on anything new perspective, or otherwise you can just indicate you agree with the person that spoke before you. Thank you. If you could give us your name and address, please.
Kathleen or Kit Saltesiak, 3381 English Hills Drive. I appreciate, as the previous discussion was talking about, I appreciate all your help. And after the August meeting, I thought most of the committee people kind of understood what our community was and is. And as stated also, from 1989, I remember being out on Alpine, and there was not, I mean, it's tripled in magnitude as all the traffic. I was really taken aback when I read about the staff recommendations being included in the agenda package, the recommendation to go ahead with development. It was stating the safety value of the redundant access for all parties outweigh the risks of additional traffic. And I'm sorry, but we're not just a risk evaluation. We're people, we're a community, and as you've heard everybody say, so we're not at risk. Even the Scott was helping in the engineer, and he was saying that both communities were overburdened, you know, way back when, and the last study was 2003. At this point now, the trip generator, the letter that they made, the estimate of how many people would be going back and forth into our communities is just an estimate. They had mentioned that there's 593 daily trips, and they pulled it apart to say this is what happens in the morning and at night. Well, that took out
1 minute left.
That took out 90. So that left the rest of the day with 503 people, cars, vehicles coming in and out. They propose 45% will go towards towards Windemere. So they'd have like 130 more people, you know, or cars and vans and trucks going in and out. So that means that if we add to ours, we would end up with 723 instead of the 593. And I really feel sorry for Ipswich, because it says, well, though 55% will go that way. Now, once again, all of these are just estimates, but I just can't imagine that amount of traffic. And then throw in the golf course and the 1,000 cars that are going to be coming from that way. So please help us out and watch the Walker plan. And that's what I have to say. Thank you very much.
Thank you. Seeing no one coming forward, entertain a motion to, no, we don't have, we'll go forward into our meeting. I'm correct myself right there. All right, agenda item at hand is the Windemere condominium development. Right now, the project that is tabled by action of the last meeting. Entertain a motion to reconvene our deliberations on this project.
I'll make a motion to reconvene.
Okay, motion by Jacob,
Second.
supported by Mark. All those in favor indicate by saying aye. Aye.
Aye.
Those opposed, same sign. Motion carried. It may be helpful to, as we usually do, go to first Paula and Scott, just to kind of bring us up to date on what's transpired since the last meeting and anything else that's significant for our deliberations. Paula?
Thank you, Chair. My report for this, I included my previous reports for reference, but I focused my report for the board on the new information. So Grand Forks Holdings LLC was at the Planning Commission 2 previous times, and the case was tabled in both both times. Most recently, it was focused on access concerns for the property and asking the developer to provide more information about their efforts for alternative access points. They submitted information, and it's been included in the report. The plan that is submitted looks very similar to what was originally seen, with the access points being Ipswich and through the English Hills condominiums. That is a private road. Again, the developer has stated that they have legal access to that road, and we will circle back to that. The other information they provided is a marked up map and 2 emails from adjacent property owners stating that they do not wish to work with the developer to create secondary points of access through their properties. Those are, let me pull the site up here, this one. So this is the parcel in question here. So the primary access points would be Ipswich, and then here on English Hills Drive, this is that plan. But here you can see the, provided by the applicant is information from the orchards 4 Mile and from this care facility to the north, stating that they are not interested in working through a secondary access through their parking lots. And so that is part of the additional information. The next is about traffic. The applicant provided a trip generation letter from an established civil engineering firm in the area. And that report, as stated by one of the members of the public here tonight, breaks down their estimate in terms of traffic based on the number of units, the type of residents that they are, and established data in the field of traffic and engineering, to show during the peak hours that are of the highest concern when traffic is highest. Quote, the proposed development will generate only 10 more AM trips from 42 to 52 and 10 more PM trips from 48 to 58 during the peak hour in the morning and the evening. That is their estimate. So, well, these increases, through English Hills Drive toward 4 Mile Road, they believe the number that states here may actually be smaller due to the long, high friction, low speed nature of English Hills Drive, discouraging drivers from the new development to go that direction. So that is from the engineer. The zoning ordinance provides guidance when deciding on PASPs, and one of them regards traffic, and I'm just going to read this whole item. This was number 5. It was one of those listed in a previous tabling motion, but there's guidance in here for what the board should consider regarding traffic. So the location of proposed uses, layout of the site, and its relation to the street giving access to it shall be such that traffic to, from, and within the site and assembly of persons in connection therewith will not be hazardous or inconvenient to the project or the surrounding area. In applying this standard, the Planning Commission shall consider, among other things, convenient routes for pedestrian traffic, particularly of children, relationship of the proposed project to arterial and collector roads and street intersections, and the general character and intensity of the existing and potential development of the surrounding area. So that is like a summary of the new information that we have. Again, I will pull that up there for reference. And so there's one other piece. There have been several questions and comments regarding density, the density of the new development, and whether or not it is in line with the master plan and the zoning ordinance in terms of allowed density. When we look at density, going back here for a moment, first we look at section 1107E of the master plan. This is regarding RPUD1 developments in particular and what density they are allowed. The guidance there is the PUD shall be designed and constructed and maintained so as to be harmonious with the goals, objective, and vision of the master plan, specifically the requirements in the zoning ordinance for what conformance with the master plan looks like. That states that if there, it must be within the residential density range of the site. It's provided by the master plan. Regarding road connections, open space, if there is a specific development vision for the site. There is not in the master plan for this site, like, for example, there was for Vista 45. There was a specific, more detailed sub-area plan. This site does not have such a plan. And then again, just making sure that nothing about the new development makes items in the master plan difficult to move forward. When we look at the master plan, I believe I pulled it up here. So the site located here it's residential existing density on the future land use map. And on the community character map breaks it down to neighborhood preservation. And these are the pages there. This has been quoted several times. Undeveloped land within the neighborhood preservation areas should be developed with a similar character and density to the surrounding homes or acquired by the city as new park space. In the city's Parks and Recreation Master Plan, there are properties called out as possible interested properties for acquisition. This is not listed as one of them in that document. So then we look to what is the character and density of the surrounding homes in terms of, is the new development in line with the master plan guidance? Doing my best with the city documents I could find, English Hills condominiums and English Ridge condominiums were both approved at 4 units per acre. Both of them went through some iterations as from the initial approval to what was actually built, like the final revision or the final phase didn't get built the first time. Then English Ridge also underwent several changes. And so from the best of my calculations, English Ridge has 28 units on 7.5 acres, which brings it to a gross density of 3.72 units per acre. English Hills is 56 units on 15.6 acres for 3.6 units per acre. That is gross density. The gross density of the proposed Windemere development is 3.5 units per acre. So it is consistent with that of the surrounding communities. However, the density you'll see on the plan is calculated in net density. That is the density we use now, is established in the zoning ordinance update that took effect 2 years ago. So that is what we use now, and what is seen here on the screen. Can zoom in a little. Here we're looking at 9 duplexes and 4 triplexes for a total of 30 units. It's 8.5 acres total, but with that net density calculation, we subtract lands that cannot be developed due to presence of wetlands and steep slopes and other similar permanent water bodies, things of that nature, which leaves a net density of 4.34 units per acre for the site at the net density level. Another thing we look at in terms of density in the master plan is, this is section 1107B of the zoning ordinance. And that's the uses permitted in the RPUD 1 district, and it allows multifamily residential, that's that up to 4 units per building. So this is the triplexes that we're considering in this case, makes this relevant. Density is not to exceed the allowable housing density of the A2 district. That is found in section 10.02 of the zoning ordinance to be 6.7 units per acre. So this is well below that cap that the ordinance puts on RPUD 1 district. So it is my interpretation that the density of this proposed development is in line with the master plan. So density is what I was talking about there. So that is the new information and some references in detail for the board in that regard. Ultimately, my report ends up saying, I believe we've gotten all the information we're going to get here. There's been ample time for the residents to provide all of their feedback. We received many letters. They have all been shared with the board in advance of the meeting. And we have had ample time for the developer to provide their documentation of their case. So I encourage the board to make a decision tonight. There have been cases made from previous tabling motions that could lead that felt to like reasons for a denial. There have also been tabling motions leaving room for the developer to move forward if certain things are put in place. I'm happy to answer any questions from the board. You all have my recommendation, which is conditional approval, stating that the developer still must prove to the satisfaction of the city attorney that there is permanent secondary access, full access through the private condominium road. And the developer claims they have legal access to that. You've heard from many residents that some members of the condominiums disagree, and that's something that the city is not a party to. That will have to be worked out between those boards, those separate groups. And if that cannot be worked out, the project cannot move forward. So that's my recommendation. It comes with a lot of, with a big caveat there. But when I look at the plan here, what we look at in terms of a PASP, the preliminary area site plan for a residential development, I believe if secondary access is firmly established to the satisfaction of the city engineer, that all of the requirements for a PASP have been met. So my recommendation is a conditional approval.
Thank you, Paula. Commissioners, at this point, do you have any questions for Paula? Do appreciate the update and explanation on density, because that has been raised by the information we've gotten and the comments from the neighbors. So try to get a complete consideration of what's at hand here. If there's no other questions for Paula at this point, if we go to Scott as city engineer.
Thank you. Not a lot of change to this plan from what we saw last time. I think the one change that you can see is that the width of the access, the emergency access, the redundant access there is at 26 feet, which could allow for 2 cars to pass each other, which is a positive thing from an emergency management standpoint. When we met with the developer at the last site plan review meeting, we did throw out a couple of comments that they have followed up on. We did ask for documentation from the property owner to the north and to the east about how they had discussed this and were not allowed to get that access. That's been provided. Paula was also able to procure a legal opinion from our city attorney's firm. I think that's very helpful if you've read through that. But there's really not much else that has changed here. We did have some discussions with the developer to try to help them find us a path forward that was as agreeable as possible with both the planning commission and certainly both the neighborhoods. We talked about one of the things was if they just wanted to drop a cul-de-sac in at the end of Ipswich and add perhaps 5 homes, 3 homes. I think staff could probably live with that. We know that there's way too many homes off both these long dead ends. But to add 5 homes and provide a permanent cul-de-sac does provide some benefits. It provides a place for vehicles to turn around. There's some safety enhancements, and that would reduce the number of vehicle trips that are generated. So those are, as an example, those are some of the things that we try to point out when we're at staff level working with developers to try to find a solution and a path forward. So I think that's worth pointing out. If they did move forward, if the Planning Commission decides to move this forward with the PASP approval, some things they could consider would be a mini traffic circle or a median, perhaps a small roundabout at the connection point with the condos. Those are things that can help reduce bypass traffic. And there are things that we've brought up with residents that have called us and with the developer as well. So there's still some talks that can be had, but I'm certainly with Paula that it's probably time to make some decisions on the land use and is infrastructure in place to support the development and some of the basic planning concerns that you'd have to work through.
Thank you, Scott. Any questions for Scott at this point? Okay, thank you very much. I think at this point, before we go into deliberations, if we could have a representative from the developer come forward and bring us up to date. There have been mention made of what you've provided to us, and if you could just express that in your own words.
Yeah, you betcha. Do I need to clarify who I am? Matt
Yes.
Frain, 3440 Johnson Street, Marne, 49435. Yeah, we've been toying around with the idea about getting a traffic engineer involved, and we did at this point in time, and we've basically told them this is what's going on, help us out here. You have to do your job, abide to your engineer standards, and just give us the good, bad, and the ugly. And he gave us the letter, and the trip generation actually, in my opinion, benefits this development. I don't quite understand how it all works. It's above my pay grade. I do know that I trust engineers, and sometimes you can get different opinions, but This guy came highly recommended by my civil engineer that's doing the project through Feenstra. And so, had some conversations, he submitted the letter, we submitted it into you. The interesting thing, though, is I find, when I go through these projects, a lot of people, there's a lot of emotion involved with it, and so we have to kind of separate the emotion from the facts. Is that this property has been sitting here for years. One of your first comments, Chairman, was, I'm surprised this hasn't been dealt with before this time. And so right now, we just want to know where we're going to go with this project. I'm excited to put the project in. You know, these are zero clearance homes. These are homes that are going to accommodate many people that have some disabilities, that are much better set up than the homes that are around them to handle disabilities. And so I'm an ADA certified builder, and that's what we're doing with these homes, is making them ADA certified. We are not making them 55 and older because ADA happens at any age. And so that is our push into it. Jennifer Taylor is actually on the board of Mary Freebed and has a lot of input from Mary Freebed on what they're looking for when it comes to handicap accessible. So we're getting a lot of input from all over the place in regards to how to design these to best fit people that, you know, every single one of us sooner or later is going to have an ADA concern. We're going to have a bum knee, we're going to have somewhere we're going to have a difficult getting around. Hopefully it's not permanent, but when it is permanent, these are set up for permanent disabilities.
Okay. Thank you.
All right, thanks, guys.
Commissioners, Rod.
Thank you, Mr. Chairman. Oh, Mr. Frain?
Yes, sir.
One of the big topics that we talked about in the previous hearings was the, I'll call it a dispute between you and the HOA with respect to access. And at least in my mind, I was of the view that unless you had peace and there was no ambiguity regarding the access, it's almost without that. I don't even want to consider the merits, and I applaud the ADA housing, but it seems until you have it clear, and it sounds like what is the status of that? Last time you were here, there was a significant dispute as to your rights to access to the site by virtue of the drive.
We have spent a lot of time in meetings and discussing topics and conversations with Giroux management. He's been there also as part of it. We have something on paper. It has not been codified as far as, you know, actual real document. I will tell you when it makes it difficult to negotiate when a planning commission is wavering, yes or no. And so it's really difficult to negotiate with somebody. So if the planning commission says, hey, we approve this PASP, now we are moving forward and we have to come to solutions on how we get access. My title company is ensuring me I have access, which gives me my attorneys for free until they guarantee it, right? And so then I also have other help in regards to getting that access codified. So of course, the public is going to say, no, we don't agree with it, because they're trying to get away from it. And I get it.
Well, it seems to me...
Nobody wants this in their backyard, I get it.
Yeah,
But I have rights too as a property owner.
Yeah, but they haven't been ascertained between you and the HOA. The HOA takes a different view of those documents, and I think our attorney, city attorney, said they were, I don't know, ambiguous or not well drafted or words to that effect. So it seems to me that you were being asked to make a decision based on what we know there's a dispute, and your attorney saying, yeah, we have access. The HOA is saying, no, you don't. And I don't think that we as a city can even consider, this is my personal view, consider the merits until, and I know our planner has recommended a conditional saying, yeah, we're going to approve it, and then you've got to clarify it, and at least in my mind, that should be clarified before we consider the merits. I mean, that's just taking it, flipping it around, but it seems to me, I don't want to approve, personally don't want to approve something when even that access is in dispute. So I was hoping that you'd come in and say, yep, here's a signed agreement, the HOA, and we agree that this is our right to access using that route. And it sounds like we're not gonna get that, at least, we don't have it tonight.
Yeah, and Paula actually mentioned that in her comments, was saying, hey, the city shouldn't really be involved in that aspect, let it work out. But also, your attorney does agree with my attorney. Mr. Bloom's letter basically agrees with Mark Hanish's letter.
He said there's a reasonable argument, I think is the words he
Yes.
used.
So, we have a strong stand, and I would say, if we are moving forward and the planning commission is going to, then our next phone call is to the HOAs to gather ourselves back together again and say, how are we gonna do this? And do we like what we've done before? But we spent, I think we had 3 or 4 meetings that lasted an hour each with the HOAs, specifically talking about these access points. And the last time I was here, when we did the choke lanes, we actually took the HOA's interpretation of the choke lanes, which were some topic of conversation from the city from a while ago, and we put them in our PA, in our plan, and that was not, we took their counsel and it was wrong. Because they had talked with the Paula and Scott also, and so I'm confident we can come up to a solution. They're gonna say no, but I tell you what, my attorney and their attorney are gonna be talking.
All right, thank you. Thank you, Mr. Chairman.
Thank you.
Any other questions? I'm fine doing chair sets.
Well, we'll continue our deliberations. We may call upon you.
Well, the developer's certainly got a right. He owns the land. He's got some rights to this. I'm going to tell you what I did today, and the rest of this group has done it before in the last few weeks. A big developer's come in and had a bigger project than this, and we turned them down. And now they're upset with us, and we end up having to meet with lawyers and stuff like that. So we're sort of supporting you on this type of stuff. So we're trying hard, and I spent half the day, Tuesday over there driving around, and yes, your driveways are narrow, especially with the snow on the ground, and I get in somebody's driveway, I thought I had another road and stuff, so it's hard. I appreciate that. But we're trying, and we've got the developer, and they've got some rights too.
Tom?
Might be a question for Mr. Frain. In your mind, is there a distinction between the access rights versus the idea of the shared maintenance and all that? I mean, are those separate issues, or are those in tandem?
So in our agreement that we have not codified, it is actually, we've actually gone through the point of what percentages get paid where and how all that shakes out. We've actually done that in our meetings. So we have an agreement on paper right now that actually lays that all out. And we relied heavily on Dro management to kind of come up with those numbers, so.
Okay. Jacob?
Yeah, I believe since our last meeting, we had those 2 main points that were set to be addressed, of course, one being the access, and the other, or I'm sorry, one being some sort of agreement that Rob was hinting on with the HOA here. And you guys already had that discussion. So I think I share a similar viewpoint with Rob when it comes to that. And then the other one, yeah, so the other point was the communication with the neighboring properties for other potential points of access for, needing those 2 points of access. And I think that point was from the previous meeting, we didn't have documentation. It was more hearsay. So I think it was looking for that. So now we have actual confirmation of that, to have a more informed decision moving forward, I believe, with that. Yeah, one of, I've worked in regulation of land development for a decade now, and yeah, I also share the same sentiments as Joe here on developer as should have access to property and be able to do something with it. But in my line of work, it's always been what's within our design square. being an engineer, you know, you have your zoning regulations, environmental regulations, and many others put into place to develop a project. And oftentimes I'd see clients or consultants come and here's the idea. In some cases, it doesn't quite fit in that square. And I have to work with individuals or groups to try to fit it into that square as best as possible. So that way, the land's still being usable, and still feasible, and also still fits within the character or the properties of the land itself too here. So one of the things I think I had a discussion with some individuals sometime after last meeting, or just brainstorming here on more of it, was the feasibility of, you know, here we're looking at the set project before us, but I think in mention two, Scott, our city engineer, had mentioned alternatives to downsizing the development, making it more feasible for the area itself. Still, technically right now, keeping the characteristic of the master plan, but a more feasible, like downsizing it, making it more realistic, fit into the master plan, I think. Because if you, again, it's one thing where on paper it might fit, but another thing going there in person, the impacts of 30 units versus a 5 or something of that nature in this neighborhood as well. Because the private drive, for instance, off English Hills does have no sidewalks, and even on Google Maps, seeing individuals walking on the streets alone. So there is the connection there, and that many individuals have brought up the traffic and transportation issues as long as there. But I think those are valid points to ponder for this, as well as the increased traffic and transportation that will be occurring with not only these increased units that we have opposed to the 5, but both neighborhoods already being well oversized for the single access that they already have. And I think doing something of a mindset of a smaller design might be a better compromise for all parties, versus, it all comes down to, I guess, a dollar amount here too. Is this ultimately, is that not feasible for a return, from the developer standpoint too? So that's up there as well.
Thank you. Elena?
I think that we've heard a lot of comments, obviously both ways with this. I agree that we do need to make a decision tonight, just to move forward with it. I am kind of leaning towards yes to it, because I think that this creates the problems that we have with English Hills Drive being that dead end, as well as Ipswich, creates that naturally, but doesn't create it as like a straight through way. I think that a lot of the residents brought up the English Hills Golf Course redevelopment. Paula, is that still, when does that timeline run out with that one?
That timeline got extended earlier this calendar year for one more year, so it will expire in
like March,
late summer, I think, of next year. I have a meeting next week with the developers to get an update on where they're at in that process.
Okay, yeah. So I think that that's going to be something else that could possibly change too, because I know that did move hands. I think that if we look at the density that Paula mentioned, for the way that the 2 previous properties were done through density, wasn't with net density. So yes, it looks like it's higher right now, but it's actually lower. So I think that that's a good thing as well too to see.
Thank you. Mark? Do you mind if I go last? Oh, no. Okay. I think that the thing that is driving this is the density that they're looking for. With going for 30 more homes along the stretch, it's creating the need, in order to meet our zoning requirements, to have a second means of access into it. And what they've identified as a second means is to cul-de-sac Ipswich and get a private drive connection through there. And I think that's why I think it was important that there was some conversation about reducing the number of homes to be added to that area to a point where it didn't require establishing a direct connection between the existing homes and this area right here. Existing homes on Ipswich, as well as existing homes along English Hills. I think that's what it really comes down to is if it would have been a lower number, it wouldn't have activated that requirement for that interconnection. The interconnection, because of English Hills and the offshoots that are along that out to 4 Mile Road, current day standards, it would have been designed differently to accommodate pedestrian movement, greater safety, visibility, also get the utility connections in. But that's not the case here. We've got a long stretch that has many homes along it already, and people living there want to maintain that setting. So it's a tough decision, and that's why we've deliberated as long as we have it. And with respect to the type of homes that they're looking for within this proposed development, it doesn't sound like it's a traditional single-family home. It's one that's made to accommodate those that either have disabilities or as time goes on, they will be in need of those considerations. So I'm not sure how that might affect the trip generation there, but so there's some unique things right to this that in a perfect world, it would have been great for everybody, but the need to interconnect between two existing areas and making a connection there where there isn't one right now, where in both cases you have your own versions of congestion on a daily basis, and you're anticipating that this will bring on even more congestion to it. So from my standpoint, given those circumstances right now, I think in order to meet those sections of the ordinance as far as looking at the impact on traffic movement and congestion within an area, and this is not as much congestion in terms of numbers through the entire day. It's those in the morning and in the afternoon where you get those conflicts come into place. And since they're asking for 30, and I think that takes it to a point where there has to be the interconnection out of necessity and not out of choice, I'm inclined to not support the plan that's been submitted to the city. Mark.
I just want to echo all of the stated concerns of the other commissioners, and particularly Jacobs about things not fitting in their boxes. At the last meeting, I made the motion to table, and I said, I'm looking at the minutes from the last meeting, that I saw no way from the motion seat to make a motion to satisfy requirements 5 and 7. And that was fundamentally due to the connections of the neighborhoods. The trip generation numbers seem reasonable to me, but I don't buy at all the claim that there's not going to be cut through problems there. We voted when we tabled that on the findings of fact that 5 and 7 hadn't been satisfied. I don't see any change has been made based on that, the reasons for that previous vote to satisfy 5 and 7. So I would like to make a motion to deny this on the same grounds. That the preliminary site plan for the new residential development featuring 30 residential condominium units on new private streets with public water and sanitary sewer services at 1204 4 Mile Road. The location of proposed uses, layout of the site, and its relation to the streets shall not be such that traffic to, from, and within the site and assembly of person in connection therein will not be hazardous or inconvenient to the project or surrounding area, and the Planning Commission did not determine that noise, odor, light, and other external effects from any source whatsoever which is connected with the proposed use will not adversely affect the adjacent and neighboring land uses.
Support.
Okay, we have a motion by Mark, supported by Joe, to deny the request, given the stated findings. Any other conversation concerning that?
Mr. Chairman, can I?
Yes.
Thank you. I wasn't sure about number 3 as well. The proposed development will be adequately served by public facilities and services such as streets, police and fire protection, and water and sanitary sewer services. And I guess I'm just asking the movement whether he thinks that that one is satisfied.
I'll be honest, I deferred to city engineer on that one.
Okay.
If Scott's happy with that, I'm happy with that.
Okay.
I think that was the point about making sure we had the 26-foot wide road through there for police and fire.
Yeah, I think if you go back to what we were saying earlier, you know, to ask yourself the question, is the infrastructure in place to support the development? It's really, that's the question.
Okay.
And it's subjective. It's not very objective because the public road ends, this is all private. I think that's why we're here, and it's why we're here for the third time. So I'll with that comment, I'll hope that helps, and I'll defer
Yeah,
you.
it does. I just focused on streets, the word streets in that paragraph, and you know, I just thought, well, big issue is the streets, but I'm not proposing an amendment to the motion. I'm just wanted to ask the question, so thank you.
Okay. All right, let's call the question. All those in favor all those in favor of denying the request indicate by saying aye.
Aye.
Aye. Those opposed?
Aye.
Motion carries. Thank you very much for your time this evening.
We're still in our meeting.
Yes. Oh, I'm sorry, I can't hear you.
We're still, yeah.
Are you gonna?
We're,
Okay, thank you.
This is a public comment I received that I'll be mentioning in my report.
okay.
I'll be mentioning it in my report. I just want you to have it. Yes. It's from someone who is in support of the amendment for his own followers.
Oh, okay. Thank you, Scott.
Thanks, Scott. We're gonna, All right, moving now on to, this is a public hearing for a project involving a proposed zoning ordinance amendment. We should leave it open just in case somebody wants to come in. So, Paula, as planning director, if you should introduce the project.
Of course, thank you, Chair. So this project before us now is a little bit different. This is a request for an amendment to the zoning ordinance, which is something that the public can request. We don't see all that often, but it made a lot of sense in this case. So the applicant is Erin, Walma, requesting that the Planning Commission consider an amendment to the zoning ordinance to permit commercial recreation as a special land use in the I-1 Light Industrial District. And so this is the property in question. It's located on 3 Mile. It's an industrial building. However, we're not really talking about this property. We're talking about the I-1 district as a whole tonight. So this is in here as a reference, but we're not focusing on one specific property. So I'm just going to go through my report here. Guidance for amendments to the zoning ordinance comes from section 18.12 of the ordinance. And it states that after a public hearing and a recommendation from the Planning Commission, ordinances go to the City Commission for final approval. And guidance from that section states that the board should consider, quote, all issues relevant to the amendment, unquote, because each amendment is unique. And so I proposed several considerations for the board, and I'm going to walk through those at this time. The first is the I-1 district and its intent. Section 4.07A of the zoning ordinance is the intent and purpose statement for the I-1 Light Industrial District. I apologize, I have all of those here, but I did not open them up in advance. Okay. The I-1 district, this is that purpose statement. It's intended for light industrial to provide various types of light industrial manufacturing uses, wholesale businesses, warehouses, and other uses compatible with one another and surrounding land uses in the absence of objectionable external effects. These are often large, boxy buildings. A lot of manufacturing uses need a lot of large open space for equipment. And the most common uses in the I-1 in Walker are light manufacturing and warehousing. However, in Walker today, we do have several I-1 zoned properties that are not used in an industrial capacity. Two that I put in my report off the top of my head, the Humane Society of West Michigan is located in the Wilson Business Park, just up the road here. That's an animal shelter, and the 3 Mile project is on Walkent Drive, and that is a youth center. These are both in industrial parks, industrial areas. They're not industrial uses, and they located there primarily because of the large buildings that we often see in those areas. I provided the board with a copy of a public comment I received today from someone asking about commercial recreation in an industrial district. And in this case, the applicant, Juno Kim, works with Grand Rapids Volleyball Club and was looking for space, looking for a large, high-ceilinged, open space where they can do volleyball practice and games. And in this case, they're requesting that the Planning Commission permit this change in both I-1 and I-2. Specifically, the property that they're looking at is in the IPUD, which references back to the I-2 district, not the I-1. So the board could consider recommending to the City Commission both I-1 and I-2, or I-1 and IPUD even, if that resonates with the board there. I have the zoning map pulled up on the screen here so you can see where I-1 zoned properties are. So in this case, the property that the applicant is looking at is in this area on 3 Mile. There's a lot of industrial property here. There's a lot of IPUD properties around the city, and even some heavier industry I-2. Another one is, the former Deltaplex, where the public commenter is looking, is over here on the far east side of the city. So that's the I-1 district. Another thing to consider is the commercial recreation use. And this is an excerpt, this is not an excerpt, this is the whole use table from the zoning ordinance. You can see it goes through every district as columns, and then the different uses as rows. Here, we're looking at commercial and office uses, and are they permitted? So commercial recreation is permitted as a special land use in the C1 and C2, and therefore in the CPUD as well. So if someone is interested in putting a commercial recreation use in Walker, they need to come to this board for a special land use. We have one coming at our next meeting for a commercial property. We've done a trampoline park recently. The upcoming one is for a pickleball gym. The applicant in this case wants to open a cheerleading facility for youth. And the public commenter is a volleyball club. And so these are the types of things people are looking to do in our community. They're active, but they need indoor space because of, I mean, everyone got here from outside today. You know what it's like out in Michigan in the winter. Not great for volleyball outside right now, but indoors would be lovely. So the definitions for commercial recreation, the table here uses commercial recreation as one umbrella term. The definitions chapter of the zoning ordinance, Article 5, breaks that into indoor and outdoor. They both apply here as a commercial recreation. Indoor means, I can pull that definition up on the screen here. Indoor facility for leisure, exercise, or entertainment, bowling alleys, sports arenas, playgrounds, rink sports, obstacle courses, rock climbing, trampoline parks, and similar activities. So it's a pretty long list, but it's as the next point in my report states they are recommended in the zoning ordinance in that use table that I pulled up as a special land use. That means every application must come to the Planning Commission to be reviewed to ensure that it's not going to create any issues, that there's safe access. You think a lot of these facilities often cater to youth, and so there's kids coming in and out of cars, crossing drive lanes. We want to make sure that the facilities are safe and located in appropriate areas. But usually they're buildings that already exist in these cases, and they're reusing existing facilities. And that special land use is how they're currently allowed in the C1, and that's the recommendation here, is not to just permit them everywhere, no problem, but to require that a special land use is in place, so a commercial recreation in the I1, or also in the I2 if the board chooses to recommend that, comes to the Planning Commission for review and scrutiny. I further noted in my report, special land uses are unique to the specific use and do not carry with the property. So if it goes from a cheerleading gym to something else, they don't get to, in perpetuity, just say it's good to go. If it becomes something else and later someone wants to put a bowling alley in that facility, it would need to come back to the board for review again. So it's not a blanket forever approval, it's specific to the use. The final option, concern that I wanted to bring before the board is the frequency of the request. I often get calls from members of the public and business owners saying, hey, I'm looking at this property for my business. Can I do it in Walker? Does this fit the zoning? And this is one of the ones I get more often. More examples have been coming up since I wrote my report in terms of how often. I've probably gotten 8 or 9 of these similar calls. Baseball coaching facility is another one I've got. Youth gymnastics, pickleball gym, things like this that people want to do, bring to our community, but they have difficulty finding space. Some of these older industrial buildings have that large open facility, but they don't meet a lot of the modern manufacturing standards. And so often when they're on the market, they're great locations for these types of uses that need that large open space. The public commenter mentioned specifically high clear heights, more than 24 feet, with minimal support columns. For a volleyball court, you can't have poles everywhere. It gets in the way of the activity. And so this is a question I get fairly often. You could say, could they get a variance? Is that a better way to solve this? One of the things we look at the ZBA is, do we get this request often, and should we instead just amend the zoning ordinance to permit it? And that is my recommendation in this case. The 3 Mile project that I mentioned earlier was permitted via a variance. It had to go to the ZBA and meet the high bar of a variance to be allowed in that location back in 2010. And finally, this is a fairly common practice amongst many municipalities. I pulled up just 2 examples. Granville permits indoor recreation centers as a special land use in their I1 and I2 districts. Wyoming permits athletic training facilities as special land uses in their I1 and I2 districts. I'm not sure if the chair can speak to Kentwood, but my guess is they might allow something very similar there as well. So this is a fairly common thing. I fully support the amendment and recommend that the Planning Commission recommend it for approval. And I can answer any questions. I know I've been talking a lot today, so I just want to make sure you have all the information you need. This is not one of the requests that comes to you often, so I wanted to give it a lot of detail.
Thank you, Paula. Rob?
Thank you, Mr. Chair. Paula, I tend to agree with you. I think this makes a lot of sense, particularly since we would review each proposed use on its own merits relative to its unique characteristics. Just curious, do some of the municipalities make a distinction between indoor and outdoor activities? That is, our zoning ordinance defines recreation indoor and recreation outdoor, and it seems like an outdoor activity, when they're coming in for special use, it's a different set of questions, I suspect, and I don't think it's impediment, but I'm just curious if some of the other locals make that distinction.
That's an excellent question that I didn't look into in great detail. So I would guess, but it would be a guess, so.
Yeah, well, and I don't see it as an impediment, or it just struck me when you were first thinking about it, I was thinking, oh yeah, it's indoors, and I'm always concerned about, traffic and those kind of things, outdoor activities, but as long as the Planning Commission has the opportunity to evaluate what's proposed outdoors and how it's going to be impacted and so forth, I don't see a problem. And from my long ago ZBA days, don't they have to find that the property can't be reasonably used as zoned as one of the requirements for a variance? It seems like
that is correct. If it's a use variance, the bar for a use variance like that is exceptionally
yeah,
high.
so I mean, even if the ZBA thought, well, this is a great use, but if you're adhering strictly to the appropriate standard, it might be a great use, but you can't get to that bar, and so it seems like it's better to approach it this way so that each applicant would be considered on their own merits as a special use. So, thank you.
Is Erin here? We know your name, your address.
Yes, so the property that we're looking at is 3239 3 Mile Road Northwest.
So, as Paula pointed out, we're not just looking at that location.
Correct.
We're looking at how it applies citywide. You could give your perspective on the reason why you're looking at an industrial property and what you found in your efforts.
Definitely. Yes. So again, my name is Erin Walma. I'm representing both ATW Industries as well as FOE All-Star Cheerleading. So we, as Paula had mentioned, we are requesting that zoning amendment to allow commercial recreation as a special land use in the I-1 Light Industrial District. Again, specifically for us, looking at 3239 3 Mile Road Northwest. For us, this gym will offer youth training, fitness, and an all-star cheer program requiring a large indoor space, as Paula mentioned, with high ceilings. Typically, these features are uncommon in standard commercial buildings. The 3 Mile Road property is ideal because FOE Cheer can share the building with ATW Industries, which is a light industrial tenant, so that can preserve the district's character. This is low impact use, so all activities will be indoors with no outdoor noise or manufacturing. Operations occur weekday afternoons, early evenings, and occasional weekends when neighbors are closed. We did do some research. Facilities like Empowered Athletics in Wyoming have successfully combined recreation with industrial spaces. So allowing commercial recreation as a special land use ensures careful review for compatibility, parking, and access. It aligns with Walker's master plan goals of adaptive reuse, economic growth, and family-friendly services. This amendment also supports local youth and families. It creates jobs, drives traffic to nearby businesses, and makes productive use of existing space. For us, FOE stands for family over everything, so we bring parents and athletes into a home away from home, and we believe 3 Mile Road is that home. I also would like to bring Tiara, my business partner, up so she can speak if you guys are okay with that as well.
We will have a we'll open for a
Perfect.
public hearing, and that'll be an opportunity for her then.
Okay.
Any questions for Erin?
Yes.
Okay, well,
Easy.
stick around and we'll continue on.
Thank you.
You had asked about other communities. Kentwood, as an example, has struggled with this in years past, and I think even now, in terms of industrial properties for tax base, jobs. Industrial is seen to be generally an advantage in the community. And the more non-industrial uses that you might have in an industrial property, it may threaten that balance that you want to have for the community in that respect. As far as indoor versus outdoor, Kentwood has treated them indoor and outdoor separately for years. Currently, the regulations make them allowable, each variety of it, and but it's restricted to the commercial zone. There's an allowance for that in the industrial zone. I seem to remember when the 3 Mile project came in, some of the conversation there was hours of operation and how they dovetail or conflict perhaps with industrial and the commercial, and a lot of them deal with kids of all ages, and kids of all ages, when they go through a parking lot, their knowledge and of the safety hazards that there may have there, I think would be and have been, I think, in the past taken into consideration. And then it's just a matter of the outdoor. I think the outdoor is one that, again, as you're looking at available industrial land, if you've got an open area, there may be some more benefits to the community to develop it, continue to develop it as industrial and not allow the commercial in there. But if you're going to allow for it, then that special land use review is ideal for that. It can take into account the specifics of that particular location, and then you make more of an informed decision that protects all people, whether they're going to the commercial project or the industrial area. So a little bit of background in that respect.
Mr. Chairman, I'm thinking this would provide some flexibility to certain parcels or buildings that might maybe not have the best industrial use. I'm thinking sort of the market would kind of sort through this. I mean, if there's a prime industrial building with a rail spur, probably going to go that route rather than going to, a baseball training facility, I'm guessing. So I feel like the market would sort of sort it out, and this would provide flexibility to maybe utilize some underutilized or less marketable buildings from their original use.
That's a great perspective.
And I think that, like, along those lines, like, I'm open to doing IPUD districts too and stuff, because we do have that variety that occurs within those districts too. We can do both, in my opinion.
Sure, Rob.
Paula, any reason why we would limit it to industrial 1 as opposed to industrial 1 and 2? Is there any distinction that would cause us to only go so far or think about going so far?
Sure. Our ordinance, the distinction between I-1 and I-2 in our current ordinance is a little interesting. So I-2 is the heavy industry. So the purpose statement there, it's intended to provide for various types of industrial and manufacturing uses and other uses compatible with one another with, so they're intended for more intensive industrial uses than those permitted in the I-1. And they might have more negative, they might be louder, or they might be smellier or noisier or those sorts of things. Really, those are the only things that get put specifically in the I-2 versus the I-1. So I will pull up the use table here so you can see the difference. There are not that many. So you can see a lot of the things are identical between the two. Most uses are the same. Their car washes are a special land use in both. Gas stations are accessory in both. Outdoor sales and display are special land uses in both. Automobile repair major principal in both. There's a few in this industrial. So it's high intensity industrial uses are a special land use in the I-2. Other things are the same. And then down here, outdoor storage. So in Walker, there are not many things permitted only in the I-2, but it does provide a few places for those uses that might be harder to co-locate with other things. I think the special land use outlet gives the board oversight. And it does open up if there are some more of those older I-2 properties that are hard to utilize now. And as more development fills in around, we have buffering and other considerations around I-2. But ultimately, I'd be supportive of allowing it in both. I think that the special land use route gives the oversight that would be essential. And while I share the chair's concerns that prime industrial property be utilized for prime industrial uses, I also think that I've seen in my career that the market tends to sort some of those things out pretty well. If it's a large vacant parcel, one of the few large vacant industrial parcels we have, we're not going to be seeing a soccer field go there. For public or for private use, we're going to see an industrial building because there's such a demand for that.
Okay, we've got this, unless we've got any comments?
This isn't technically deliberation, is it? Because we haven't opened up public comment and.
Correct.
Okay, yeah, I have nothing. Thank you.
Okay.
I'll make a motion to open the public hearing.
Okay, motion by Elena, supported by Rob to open the public hearing. All those in favor indicate by saying aye. Aye. Those opposed, same sign. Motion carried. Now we have an opportunity for public comment. If you come forward, give us your name and address and share your thoughts.
All right, I'll kick us off. Do I have 2 minutes or does it not matter?
We'll start off at 3
Okay.
minutes and see where you are
Okay,
at that
all right,
point.
all right. Well, it's a pleasure to meet everyone. I'm Tiara Johnson. I'm here representing myself and my husband, David Johnson, as co-owners of FOE All-Star Cheer, alongside my business partner. You heard from Erin already and her husband, Andy. And I understand there's a bigger picture going on here regarding zoning, but our focus right now is on the request to amend the zoning ordinance and allow commercial recreation as a special land use at 3239 3 Mile Road Northwest, or what we would like to call FOE HQ in the future. So thank you again for listening to us today. And I wanted to just piggyback on Erin some and to share our why, or why this matters for us to have an all-star cheer gym here in Walker, and the impact it will have on the families and surrounding community. So all-star cheer isn't just about athleticism. It's about building character, resilience, and those lifelong skills. And according to the U.S. All-Star Federation, there's over 144,000 all-star cheer athletes in the U.S. So, and it's growing. So there's a lot of athletes and a lot of interest for this type of sport. And cheerleading, it does require physical fitness, but it also requires the development of interpersonal and personal skills as well. And these athletes gain these practical skills over their life. These skills are discipline, teamwork, and goal setting, and these are all attributes that are important for building a community. We also know that all-star cheer gyms help the economy. Both youth and amateur sporting events generate a record $90.8 million in revenue last year in West Michigan alone. And so this drew over 282,000 athletes and visitors to our region. And this activity obviously supports local jobs, fills hotels, and then brings new customers to area businesses. And so we're hoping that FOE can continue this momentum here in Walker and make this a destination for families.
1 minute left.
All right, so for our family and from others that you'll hear from tonight, FOE All-Star is intended to be more than a gym. It's a home away from home, as Erin mentioned. It's where our kids are going to learn perseverance and teamwork, and it's where we're hoping that friendships will continue to be formed and memories will be made over a lifetime. It was about 19 years ago that my husband and I brought our first child home to the Apple Ridge Apartments here in Walker, and we didn't know what the journey was like ahead. But over that time, we learned that true community requires relationship development and that we need to invest in our kids and create spaces where they can grow and thrive. So by approving an amendment specific for FOE, you're not just allowing our business to operate, but you're investing in a space that will help launch young lives and strengthen the community. And we also believe that our request helps to support the Walker's Park and Recreation Master Plan for community connection, supporting that high quality of life and economic growth. Thank you so much for your time and consideration. I do also have 5 letters that were submitted from other cheer families. What is the best process to get that information to you? Give it to you, Paula.
Yes, if you get them to me, I can include them in the documentation of the meeting.
Okay, can I just hand them to you right now then?
Yep.
Okay, thank you.
We appreciate your enthusiasm.
I didn't make 10 copies for everyone, so sorry. Thank you.
And I can share these with the board.
Okay, thank you.
Later.
Not very good at public speaking, so. Do you need to know my address? If I don't
Yes,
live?
name and address, please.
Okay, Jamie Clement, 516 Hill Valley Lane in Sparta. And this is my daughter Paisley. She is my all-star cheerleader. When I asked her what cheer means to her, she told me it's her second family. Cheer is where all of her friends are. It's where she learns how to work hard, how to be a good teammate, and where she grows as a person and athlete. Our cheer family is truly a family, and being without since their previous gym closed has been extremely difficult. Cheer is a rapidly growing sport, and the greater Grand Rapids area is lacking in options for these athletes in the world of all-star cheer. We currently have athletes in Indiana in order to continue in a sport they love, and that is just not feasible long-term. Many have had to put their cheer careers on hold until they have an option in the Grand Rapids area. We need a place here that our kids can call their second home and where they can continue to learn, grow, and well. Sports have been a safe haven for so many youth for decades, and we are hoping to bring a safe haven here for our kids. We thank you for your time and consideration.
Thank you.
Who's going to speak?
I don't know if she's tall enough. My name is Sarah. I actually live in Rockford at 10060 Wolven Avenue, but I'm here to speak for FOE Cheer. Here with me. Jamie got me all worked up. So, I'm here to speak in support of rezoning a local building for a new all-star, my gosh, sorry. A new local all-star cheer gym. My daughter Kenzie was a longtime member of the previous cheer gym, and when it suddenly closed, she was devastated. All-Star Cheer is not just an activity for her, but it's her passion and her community. It's her second home. An All-Star Gym brings a higher level of training, discipline, and opportunity, giving our kids the chance to compete, grow, and shine on national stages. The new gym would provide a safe, positive space where athletes can build confidence, friendships, and life skills that extend far beyond cheer. Families like ours rely on places like this to keep our children engaged, supported, and connected. Approving this rezoning would allow us to rebuild the cheer community, ensure our kids have a place to thrive together. Thank you for considering what this means to us and the future of local cheerleaders.
Thank you. Any other comments? Yes, you may.
Hi, my name is Juno Kim, and I'm the guy that wrote the letter. I live on 4288 Orchard Creek in Grand Rapids, Kentwood City, but the property I'm looking at is at 2574 Hillside Drive. It's the parking lot of the Deltaplex, former Deltaplex. I could just echo the same sentiments in terms of the community building aspects of having an athletic, a safe place for athletic activities. My goal was really just to get kids off of, particularly youth, off of their devices, coming together, making new friends, and just building the community. I started the volleyball club just a year ago, but it's just been a year of tremendous growth, going from originally 4 teams and about 70 players to now to 11 teams, and we're way over 100 athletes now. What I've discovered in terms of spaces, I am considering another space in Kentwood City, again, light industrial zone area, but a lot of our athletes are coming from Rockford, even Kent City, Sparta, Belmont, Northview, so a lot of them are coming from the northern part of Grand Rapids, greater Grand Rapids. And just looking at this property, I thought it's very ideal on the intersection of the 96 and the 131. And so it's just a 30,000 square slice of 165,000 square feet. In terms of the timing, though, we operate close to business close, which would be around 4 p.m. to 9 p.m. would be our key training times during the week. And then on the weekends, Saturday and Sundays, we could host competitions as well as training for our athletes. The idea would be to just create, a headquarters for this facility here in Grand Rapids. Right now, there are literally hundreds of girls and boys just being turned away, cut from the existing clubs. The existing clubs are located in Cascade area. You have Cutlerville, NBA in Cascade area. Far Out is located in Cutlerville. You have Muskegon with Inside Out, and then Hudsonville with Impact. These are the large clubs. But with these large clubs, they don't have the capacity to accommodate every single athlete. They're literally cutting people. I'm just scrambling. I'm using the YMCA in Cascade. I have Ada Christian in Ada, and then Byron Center, the courthouse athletic there. And just literally driving around all over the place looking for buildings with high ceilings to accommodate them. This would be the most ideal location, and just very centrally located, and I'd love to expand and grow in this city if possible. So just here to voice my support. Thank you so much, Paula, for answering my call. Thank you.
All right, thank you.
I'll make a motion to close public hearing. That's everyone.
Motion by Jacob, supported by Elena to close the public hearing. All those in favor indicate by saying aye.
Aye.
Those opposed, same sign. Motion carried.
I was gonna say, if everyone's good, I can go forward here. Okay, awesome. I think we're pretty much all in agreement on this. My one discussion point here was, should I add I-2 to the list as well? Okay.
Yeah.
All right. I'll make a motion to move forward, to forward a recommendation to the City Commission for the approval of the request to amend Section 5.03 of the zoning ordinance to allow commercial recreation as a special land use in the I-1 and I-2 light industrial district. Findings of fact: the commercial recreational use is aligned with the purpose and intent of the I-1 and I-2 light industrial district. The special land use review process is required to ensure safe and compatible commercial recreation uses in the I-1 and I-2 district. Development trends in the city are consistent with the requested zoning ordinance amendment. The requested amendment is consistent with all other applicable aspects of the zoning ordinance and the master plan.
Support.
Okay, we have a motion and support to forward this along to the city commission. Any comments? I've got one. I just have consideration of whether indoor and outdoor are both allowed. The outdoor in the industrial zone, I think a point was made that it's prime property and vacant property. They're not, it's more likely it'll go industrial, but you are making that opportunity available. But so that's my only misgiving on it.
Oh, no, that's fair. And I had a similar, I feel the same sentiment to that too, but I think that would be determined in the SLU, right?
Well, if the allowance was special land use for commercial recreation indoor, it was specific to that, then it would be perfectly clear and there wouldn't be any interpretation on it. But that's just my viewpoint. I respect everybody else's perspectives as well.
I'd say we should explicitly allow it if for the SLU. If there's a vacant property and it's not worth building on, then let it go to good use. You know, we're going to find, before they're built, we're going to find a large concentration of big open areas. In my mind, since we do have the SLU process for any obvious safety concerns, all I see is increased property values and the public getting benefit.
It's nice to end with a feel-good story. It gives you a little faith in the human race, you know? All the stuff's going on, and here these folks have been smiling, these darling little kids. Yeah. They're gonna amount to something, damn it. Good, right. Darn it.
All right. So, we've got a motion on the floor. All those in favor indicate by saying aye. Yes. All those in favor indicate by saying aye.
Aye.
Aye. Those opposed, same sign. Motion carried. Thank you. Okay, just bear in mind that there's a step in the process, goes to the city commission for an ordinance amendment, and if it is adopted, you'll have to make specific applications for those. So, but, yeah, good enthusiasm.
Goodbye.
All right, Board, I have just a few things for you. We do have 2 items on our December 17th agenda. There were 3, and one's getting pushed to January, so hopefully, I don't believe either of them are particularly. One is a special recreation, or a commercial recreation in a commercial district for a pickleball gym. And the other thing I have for you is the 2026 schedule. I can email you this as well, but I brought hard copies if anyone wants to take one home with them tonight.
Okay. Any other conversation?
I'll move to adjourn.
All right. Okay, motion by Rob, supported by Mark to adjourn. All those in favor say by aye.
Aye.
Aye. Those opposed, same sign. Motion carried. Thanks.